so much for being here.
Thank you. Well, first of all, can you hear me okay? Okay. First of all, thank you for coming. I know Wayne Sitio was the announced speaker early on, and I'm a poor substitute for Wayne in terms of what I know about the commission versus what he knows about the commission. So I appreciate your willingness to come anyway, and let me stand in for him. So as Kent said, I am a real estate commissioner, and I've been a commissioner for 6 years. Do you guys know how many real estate commissioners there are? Who knows? 5, right? And they have to be from different counties. None of them can be from the same county. And each time they're appointed, it's for a 5-year term. And then you may be reappointed, or your position might be refilled. And generally, when there is a new administration, they do reappoint commissioners, so that could be happening anytime. Anyone in this room could be just waiting in the wings to fill my seat. You never know. With that said, you know, I volunteered here for many, many years. 20 years ago, in fact, I was the president of GAR. And at that time, I would never have believed the things that would happen. You know, going forward, the invention of the iPod, Google, both the noun and the verb, never would have thought about it. Text messages, Bluetooth, Instanet, showing time, all these things, all these decisions regarding our industry were made in this room, you know, to adopt them. And so this room is a room to be respected. And, you know, it's something I never would have dreamed when I sat here as the president that I would ever have the honor of being a commissioner. And, you know, with that said, it's a very difficult position to be in. I think the hardest thing you can do is judge your peers. Every decision we make in that regard is agony. And so in addition to kind of giving you guys a sense of what we've been doing over the last year and what things are upcoming, I want to go over a couple of cases with you because I think it's really interesting for you to see how we work. So every other month we meet, and the first part of the meeting is bureaucratic stuff. There's an agenda. It's always posted on the website. And as part of our meeting, there's always an opportunity for you as members and people from the public to address the commission. Tell us what's on your mind and what you're thinking about. And I would encourage you, I know there's a requirement to attend to get hours, but it's also a really interesting experience. And we really want you to come and give us your comments. We know that we're not the smartest people in the room. You know, we always want more people to give an opinion because better decisions are made with more opinions. So I would encourage you to come to our meetings. So when we hear a case, it's interesting, or how things are brought forward to us. A complaint would be filed by the public, and then the investigators investigate the complaint, and they spend a lot of time making phone calls and collecting paperwork and that type of thing. And then they summarize the complaint in something called a broker B. And a broker B is one of the most amazing inventions, in my opinion. And that's because the broker B makes the process anonymous. So when the investigators bring the complaint to us in the form of a broker B, we don't know who anybody is. It's coming forward as a complainant and a respondent. And so in this way, no favors can be granted to friends, and no punishment can be dealt out to an enemy because we don't know who you are. We're just listening to the case on the merits of the case. And so as we go along today, I'm going to bring up a couple of cases and see what you guys think of what should have been done and then tell you what was done. I think that would be kind of fun to see. So once the broker B is presented to the commission, in executive session, which is where it's not the public portion of the meeting, we go over every single case. The investigator presents the investigation, and we debate, all the commissioners together debate, what should we do with this case? Should we dismiss it? Should we offer something called a pre-settlement, a pre-NCA settlement, or should we advance to a hearing? And so if we dismiss, there's a letter of dismissal or closure goes out to all the parties. If we offer to settle, we send a letter to the parties saying, based on the evidence that was presented during the investigation, we think that there could be these violations, but to save time, we're willing to offer you a fine, a letter, a class, something like that, and you can choose to take it, or you can choose to proceed and go to an NCA, which is a hearing. And in the hearing, you can have an attorney represent you. The state has a prosecutor there to prosecute, and a commissioner is serving as a judge or a hearing officer. So in that room, there would be a judge at the table, there would be a defense person, possibly you to testify, then there's a prosecutor, and we hear evidence, we hear testimony, we accept or decline the testimony, the evidence, and then we make what we call findings of fact, or a hearing officer's report. We bring that back to the entire commission, and the commission reviews in executive session the hearing, the transcript, everything, the opinion of the hearing officer, and then we decide together what should happen. So that's kind of how that process goes. And I'll tell you, once again, that is agony. Trying to make a decision on your peers when you yourself have stood in the shoes is a very, very difficult thing to do. And with each one, we probably spend, 4 or 5 hours going over cases every time we meet. It's a very serious thing, and we don't take it lightly. So that's kind of that part, and that's coming up. I'll give you a little bit more about the broker bees soon. But some of the things we have upcoming, we're trying to convene a task force to look at teams. And just keep in mind, we're not trying to find a way to regulate teams out of business. That's not the intent at all. But as is often the case with regulation, which is government, in my opinion, it rarely keeps up with the practice out in the private sector. So teams have been operating for years with no guidelines, really. They're not even defined in the rule book. And so when you think about the commission's charge is to protect the public. So how do we protect the public from something that isn't defined in our book, and there's no even framework laid out in the book for how a team should work? So in the next meeting, we're probably going to have that committee convened. Those meetings are public, so there'll be a task force, but other people can come and give their opinions. So once again, I want everyone to know we're not trying to clamp down and limit that practice in any way, but it should be defined. And the main issue, as we see complaints come in, people who are working with teams oftentimes don't know who they work with. They don't know who is representing them. And sometimes there's a phone that gets passed around to whoever happens to be on call that weekend, and the customer doesn't know who they're supposed to be calling. They don't know who represents them, and neither do the other brokers sometimes. So we're looking at just trying to find some ways to outline this. And when I go to the Arello conference, which is the regulators conference, it's not very exciting, as you can imagine, but the interesting part is that we see what we think of as a problem that we're dealing with at this moment in time in our market. When you go out into the world and you talk to other commissioners, it's not like just a drop in our pond. It's actually something that is a wave that goes across the country. And so when you talk about teams at the commission, at commissions around the country, everybody is trying to come up with what do we do about teams? And it all comes back around to responsibility. Who's responsible? And some states are even regulating the names of teams, saying it cannot be the blue sky team. It has to be associated with a person's name who can be tracked down at the commission via a license number and a name. So that's just an example of what one state is doing. Another state is saying, okay, the team leader has to be a qualifying broker, because the team leader seems to be the person who is giving a lot of advice to their team members without seeking the advice of the qualifying broker. So those are just some examples of things we're considering, and I'll encourage you to watch the agendas. They're posted. You'll see what we're doing. You'll see that we're going to be convening the team's task force, and you'll see who those people are, and you can reach out to them and see when the meetings are going to be, and you can attend the meetings. So that's one thing. And then I know you all are aware of our core course that we created, something we're very proud of. And I know it has been considered a pain by many people, but the goal was to get away from 8 hours, a repetitive 8 hours, things that you had heard every year, every cycle for as long as you can remember. We were trying to make it be something that was fresh, interactive, and an adult learning process. And so we're very proud that we created that. And as part of that, because you have to take a core course every year, you can imagine we were a little short on instructors. And so we Todd Clark created a boot camp to try to really get people excited about becoming adult educators. And he and a guy named Robin Dyke, who do a CCIM boot camp in a similar way, have created this amazing program. And I've been a judge at one. It's very interesting. It's 2 days. It's very intense. And that you're given intense instruction on presentation, how to do PowerPoints, how to be in front of a room, how to engage people. And then you're recorded. And then you're judged. They play your recording. They judge you. There are judges in the room who judge your presentation and give you scores and that type of thing. And so then if you get out of the boot camp with a pass, I'll say, then you can be a core course instructor. There is a boot camp starting tomorrow. It's the next 2 days, and it's in Las Cruces. So it'll be interesting to see what instructors come out of there. And I know we have some core instructors in the room, and I'm grateful to you for being willing to be a pioneer and try this adult learning process. And thank you all for giving it a go, too. I hope that you found it valuable. Can anybody comment on that? Have you found it a valuable course? Better than the mandatory, I hope? Yeah, a few nods. I know nobody likes to be required to go anywhere, but we tried to make it better anyway. So that's that. We have some rule changes coming up. And so at the end of this presentation, I'm going to quickly go over the rules that we're considering changing. We think of that like we have the rule book open. So we've got certain sections of the rule book open, and we're trying to correct some things that happened before. There's always a trickle. When you change a rule, there's always an unexpected consequence. And so that usually means you have to clean up some stuff later. So we're going to do that. And then there are some things that we're trying to not only clean up, but kind of refine. So we'll be going over that in detail in a few minutes. But first, I kind of want to go over a broker B. So let's see here. Okay. I don't do this every day, so hold on. There we go. Okay, so this is a broker B. And we have, so this is exactly the format that they come to us in. Oh, sorry, hold on. Can we get the,
Yep.
Okay. There we go. Okay, so case number one, we have we received a written complaint from a buyer homeowner stating that his respondent, stating that the respondent, the buyer broker, and AB means associate broker. So the buyer broker, associate broker, failed to disclose pertinent facts about the property. She bought and misrepresented the property. And then generally the respondent's QB is brought into the case. And so in this particular case, the complainant says she hired respondent to take her to look at a few homes that she personally found online. Her first alleged complaint is that the respondent did not contact complainant about the listings, but rather the complainant had to do all the work. How often do you hear that? I asked her many times for comparables, and I was told that they don't do that here. I pushed for it, and finally I got some houses that were given from her colleague And they were poor comparables, but I put my trust in them. There was a problem with gophers in the yard, and a stipulation was this was to be taken care of. I had to hound them about it, and respondent got very upset and turned it over to her colleague. Again, she didn't want to deal with me, of course, because the house was sold. When I asked her about the big gopher piles in the yard, she said, "Oh, it's no biggie. You just have to pour things down the holes. My husband does it all the time." I looked up this procedure since we never ever had gophers, and this was not an easy fix. I asked her to negotiate this. What I want to reiterate was that the owner of this home was in jail, and I had his aunt and family member selling it. It was a disclosure. This was a disclosure she should have told me. Had I known, I would never have bought the home. This meant there was some kind of drug activity going on. Can you imagine? I felt like I was duped by her never telling me about the guy in jail and the colleague as the seller. Also, to be saying things that she did when it didn't appraise out was so unprofessional. So let me get this down a little bit. You can see why we spend hours going over this. So on March 26, 2018, the listing broker to the subject property introduced himself via email, explaining his role in the transaction. He stated that he represented the seller on the sale. "I'm sorry the gopher treatment has caused a problem. The seller has always been agreeable to have that done." He further states that he was the one who ordered the treatment. He said the original pest company is a professional company, for whatever reason they didn't do the work. The listing broker scheduled another pest company and stated that he would be taking care of the payment. He asked the complainant permission to have a new pest company on her property and reiterated, "This company is not the original company I contacted, and I'm sure they'll do a professional job." The complainant alleges that the respondent hid the fact that the seller was in jail and failed to disclose it to her that the house appraised lower because it was not in the shape you led me to believe, despite your telling me that nothing was wrong with the house, even when I questioned it being on the market 400 days. So this is the kind of thing you get. That is the complainant giving their side of the story. So then we have the respondent has an opportunity, let's see, to give their side of the story. And this is where it's very interesting. So the respondent says she was contacted by the complainant inquiring about a home she found on Realtor.com. In total, there were 19 homes that she was interested in. Some were sold, some were under contract, and a few others were investment properties and leased or part of a HOA. I was assuming some of them were probably on Zillow too, and she had to do a lot of work to figure out they weren't really for sale. They narrowed it to 10 homes, 6 being viewed by the complainant. After viewing the property in question twice, the complainant made an offer because it met her criteria. The home inspector was a licensed New Mexico contractor, and he was chosen by the complainant. Respondent goes on to say they dealt with the backyard separately. There was evidence of some type of pest activity in the backyard, and the holes appeared to be created by gophers. I explained to the complainant that this was fairly common and she would need to have them addressed professionally to see what best course of action to remedy the situation. I contacted Redacted Pest Company to assess the situation. I was informed he would be going over to do the inspection. I tried to contact him numerous times to get a copy of the report, and after 2 or 3 days was informed he had been incarcerated. I immediately contacted the complainant to explain what happened. She would not respond to me. Finally, I asked the listing agent if he would contact the pest company and have them take care of the issue. A Redacted Pest Company went out, took care of it. I want to reiterate, it was the first inspector contacted that later became incarcerated, not the seller. Complainant alleges that the identity of the listing agent was misrepresented. I shared with complainant numerous times who the listing broker was. He was the listing agent. Complainant alleges that the home being on the market for a long time caused the appraisal to come in under the original sales price. And complainant speculated that this was induced because the seller was in jail and not disclosing it. A home being on the market for a year and 6 months is not uncommon, this is in quotes, in our market, and had nothing to do with any form of illicit activity. The appraiser was not from New Mexico. He was from Texas and unfamiliar with our market. Then she proceeded with the closing of the property. Although the listing broker was not named in the complaint, he responded with the following. As per her agreement, the complainant had requested a number of repairs. They were all completed prior to closing, except treating the backyard for gophers. The pest inspector was unavailable to do so. We know now why. It took approximately 2 weeks for the treatment to get accomplished due to the purchaser not returning their scheduling calls. In an email dated March 19, 2018, the respondent tells the complainant the following. I just spoke with so-and-so. He's the gentleman who was scheduled to take care of the gopher problem at your home. We've been trying to reach him for weeks to have him confirm whether he did or did not take care of this. He told me today he had not. Apparently, he got into some kind of legal situation the day before and one was unable to honor his commitment. It appears that the seller misread the email dated March 19th from the respondent because she assumed the seller was in jail. I was never told the seller was in jail, and she quotes, I'm assuming because he was in jail, he came to do his contract promise for gophers at a later date. On March 20th, 2018, respondent responded in an email. The seller was not in jail. That is a misunderstanding. The person who had the difficulty is the gentleman who does the pest treatment. Respondent QB then gave his answer. Respondent was given an opportunity to respond to the formal complaint on November 7th, since he had not done so on August of 2018. The QB statement mirrors that of the respondent, except that it also includes the following. The seller had the home treated for termites December 2016. The same contractor had chosen to treat the termites was called and agreed to set traps for gophers. He did not show up and would not respond. The buyer was provided a list of available home inspectors. She chose one that is the only licensed home builder/inspector in the redacted city. He's been a custom home builder in the redacted city for over 35 years and a home inspector for over 20 years. The items from the home inspection that she requested to be repaired were completed. The seller was not in jail. The pest management contractor was in jail. So we look at the investigator's narrative. So the investigator will give a little brief summary of what they found. Complainant alleged the respondent failed to disclose pertinent facts about the property, like not disclosing there was a rodent problem in the backyard. Records show the treatment was addressed by a second pest control professional. Complainant also alleged that respondent misrepresented the seller being in jail. Respondent says that it was not the seller who was in jail, but rather the first pest control professional. Investigator spoke with the respondent QB and learned that while the home was listed, it also had a tenant living in the home on a lease with the former owner of the property. This was the reason the house was on the market for 400 days. Records show that the seller completed the requested number of repairs of the complainant prior to closing, including the rodent problem. So, this is a great example of a complaint that came forward. Took a lot of time to investigate, to get the paperwork back and forth and that type of thing. And one thing I want to point out in this is we see a lot of complaints, but we all have stood in the position where there was a mistake made. And it really comes down to how did you resolve the mistake? And how good was your file? Did you keep a good file with good records that you can pull them out and you can say, on this date I emailed the person and this is what I said. On this date they responded and this is what they said. Your file, your correspondence, your logs is always going to be your best defense. And responding to the commission complaints with as much information as possible is the best way to protect yourself. So this was a good example of a bunch of misunderstandings, and they had information in their own files to protect themselves. So what do you think happened? What do you think happened? What would you have done if you were a commissioner? Anyone else?
Same.
She said found him not in violation.
I agree.
Same.
The only thing that I think that he did that he shouldn't have done was to order the pest inspection himself instead of giving the names to the complainant to do it herself.
Yeah, there's always a little bit of a variation in practice. We see that all the time. Especially there's a lot of concern right now about what do they call it, a negligent referral. And there's a current case that's terrifying about that Ashley Strauss-Martin gave a presentation on in Santa Fe last week, where a broker's being held responsible for giving his seller the name of a roofer who then subsequently burned the house down. And unfortunately, the roofer was not licensed. And despite the fact that the broker gave two names to the seller interviewed both of them. The seller personally hired the one which was unlicensed, unbeknownst to the broker. And of course, that was the cheaper bid. And then he burned the house down. So the homeowner's insurance covered it. That was great, $285,000 house. The homeowner's insurance covered it. But then they decided to go after the broker. The broker and the qualifying broker, associate broker, qualifying broker. And what they're saying is it was a negligent referral, that they had a duty the associate broker had a duty to refer licensed individuals, and the qualifying broker had a duty to ensure that the associate broker knew that. That's terrifying to me. That's as scary as should have known. So anyway, in this case, there were no violations found. We call that a closed case. So it was, yes?
Assuming that someone was in jail, is there an obligation to disclose?
Yes. And it has to do with the seller's ability to perform. So can they sign when they're in jail? Can they close when they're in jail? Are you sure? That's a little scary. That's a little scary. We just went through that in my office recently, and I think it very much depends on where the person is incarcerated and how available they are. You know, if we just found this out actually in one of our buyers, unfortunately, was in jail in Hawaii, and they generally do not allow any kind of access for signatures. They don't try to offer any kind of way for someone to come in with a notary and authorize the signature or notarize the signature. So I think
That's the question again. What's the law?
the law doesn't address that. That would be a matter, though, of your person's ability to perform under the contract. So if you determine with your customer that you have access to them and they can sign the papers, then I suppose it's irrelevant. You think about, though, do you have a duty to disclose it to the lender? Can somebody who is incarcerated get a loan? Can they make their payments? Can they keep their job? Okay, yeah. So it's like most cases, they're individual. Between houses and people, no two are the same, right? So everything's individual. Yes.
I had a situation where my seller was incarcerated, but he was here in New Mexico, and it was quite a process to get the power of attorney to get her mom to sign for her, but we were able to do it. But they have all kinds of rules and regulations.
Right.
So
If it's going to put you in a position where you're going to miss the deadline, I would say you got to figure out a way to respond or disclose. Yes, ma'am. The investigator writes a letter, and in the letter they explain that the case was investigated, the case was presented to the commission, and the commission found no violation. I don't know. In that particular case, I don't know. They would have the ability to write back and try to get us to reconsider, but we don't often have that happen, so I don't know. Yeah, that's where Mr. Sidio would have been a better choice here. He sees more of that side of things. So here is a second case, and so we have the Real Estate Commission initiated investigation. And we always start with that line. It's not the commission choosing to initiate the investigation. It's that a complaint came in. Because of the complaint, we have to initiate an investigation. So from a complainant purchaser alleging that respondent A, the listing broker, and respondent B, the respondent A's qualifying broker, represented that there was a shared well agreement on the property complainant repurchased, but the agreement was not valid. Additionally, respondent A is the sister of the seller of the subject property and did not disclose this relationship to the purchaser, to the complainant. So the background information: on January 10th, 2012, respondent A listed the subject property. As part of the listing agreement, Part 2 of cover page to broker duties disclosure, respondent A disclosed, I, seller's broker, working with seller, does have a material interest in material interest or business relationship, personal or family nature in the transaction, including compensation from more than one party. Sellers are broker's sister and brother-in-law. It should be noted that this disclosure was part of the listing agreement. So the listing broker is disclosing to his sister that they're related. So that's something. On August 16th. The issue of this complaint is there was originally an undated 2-sentence agreement signed by the seller in the subject transaction and the adjacent property owner regarding a well on the adjacent property, which could be shared for a cost of $400 annually and half the cost of all repairs and maintenance associated with the well to cover the electricity costs. The agreement was not recorded, but served as an agreement between the two property owners to use the well for purpose of irrigation and yard water. At the request of the purchaser, complainant, a new well share agreement was executed at closing between the purchaser, complainant, and the adjacent property owner. The problem arose when the adjacent property owner later sold his home and the new owner had a pool installed, and the cost of usage of the well increased, and the two neighbors could not resolve the dispute amicably. So we have a complainant statement. The MLS data sheet advertised the property as having the following utilities: electricity, sewer, shared well, and city water. The complainant stated when the agreement, shared well agreement, was provided, it was noted that the agreement was very generic and not adequate. We insisted that a proper shared well agreement for the property be produced and provided by the sellers prior to closing. A new shared well agreement was provided at that time and was signed by the next door property owner. The new shared well agreement was signed by both parties on October 3rd. Several years went by with no issue. In the summer of 2017, the adjacent property owners sold their property. There was no new agreement regarding the well and the new purchaser of the adjacent property. The new owner of the adjacent property began building a new pool in the backyard and was tying the well water and the well's electric meter into her pool. The complainant states neither the realtors, owners, or the title company provided or disclosed the permit on the well located at redacted address. The well is registered with the state engineer's office as one household, non-commercial, trees, lawn, and garden not to exceed 1 acre. The sale of our property with a shared well agreement was illegal, considering that the well itself is not permitted to be shared. Regardless of any written agreement between the parties, the well was not legally allowed to be shared because of how it is permitted with the state engineer's office. Complainant also alleges that the respondent A, the listing broker, did not disclose that she was related to the sellers, who were her sister and brother-in-law. So now the respondent gets to give an answer. So the respondent A states, I vehemently deny that I ever indicated through listing documents or to complainant buyer's broker that the sellers of the redacted address had any type of ownership interest in the well owned by the property owners of adjacent property. Complainant indicates that I should have provided copies of the permit for the well prior to selling the seller's property. Why would I need to provide any documentation about a well that clearly does not belong to the property being sold by my clients? I had no duty to investigate with the state engineer's office regarding a permit for a well that does not belong to the property I was selling. Respondent B, QB response. I always review the documents and answer any questions that my associate brokers have concerning the deals that they're working. I've received the office files since this complaint has come to me, and I have found nothing that was wrong on any documents. I talked with Respondent A about the accusation that she implied and represented that there was an ownership interest in the well, and both property owners and she said they never indicated her client had an ownership interest in the well. All she stated was there was a shared well agreement, and the well was on the property of the neighbor, and the agreement was sharing the use of and expense of the well. I'm sorry that the complainant researched years later and found that the document was not transferable when someone else bought the property beside them with the well. Respondent A had nothing to do with the document, and neither did her clients. It was a new document that the two owners agreed to, and we as brokers had nothing to do with. Respondent A is not an attorney and can't give legal advice on an agreement that the two owners decided on. Respondent A disclosed and shared everything her client told her about the shared well. Unfortunately, years after the complainant purchased the property and had a falling out with the neighbors, he feels it's all the seller broker's fault. To state the facts, he did not buy a property with a well on it, but one with a shared well agreement that the neighbor drew up and both signed. The brokers of both the buyer or sellers do not get into the state's legality of well permit, whether it was done correctly between the state engineer and the individual who got the permit. So we look at what did the investigator find. In the initial agreement on page 7 of 12, Random Form 2104, in the paragraph titled Wells, the buyer complainant had marked yes to the question, does the property include a well? The seller marked no, the no box, and added the statement, well located on adjacent property, and both buyer and seller initialed the change. So it seems like they did tell the buyer, it's not on our property. On the property disclosure statement, Form 2301, page 2 of 14, the seller's response to the question, any well sharing, driveway sharing, road sharing, or other contract to which the property is subject. If yes, explain. Seller wrote, shared well. Under water supply, page 5 of 14, the seller checked city municipal water. To the question, is there any water source for the property for any other use? Seller noted, domestic well for irrigation. On 8/14 of 12, the buyer acknowledged receipt of the form, information sheet, water rights, and domestic wells. On 9/21, there was a domestic well inspection done by a well service company and requested by the buyer's broker. A title commitment was issued with an exception noted, possible rights into unrecorded shared well agreement. The transaction was closed on 10/3. As of closing, the buyer, complainant, and the owner of the adjacent property drew up and signed a new shared well agreement between the two parties and signed it. Regarding the issue of non-disclosure of the Respondent A's responsibility to the sellers, the investigator asked Respondent A to provide a copy of a written disclosure to the buyer, complainant, that the sellers were related to the Respondent A as her sister and brother-in-law. Respondent A replied, I completed the form the attorneys for Random provided for a listing. I disclosed that I had a familial relationship with the sellers. At that time, there was no place where the brokers were required to disclose that relationship on a purchase agreement. That has since changed, and I certainly never hid my relationship from the broker, from the buyer's broker, or the buyers in any conversation. So what do you think happened on that one? Yeah. I can tell you, by the end of the executive session, we're so cross-eyed we can barely find our way home. Respondent, complainant, Respondent A, Respondent B, Respondent QB, Complainant A, Complainant B. So anyway, in this case, this was 2012. Yeah, yeah, yeah. So in this case, we did find possible violations. So even though it may not have stated it had to be disclosed on a purchase agreement, your broker duties say you must disclose any conflict of interest. So it looked like we had, prior to the time a licensee generates or presents a written document that has the potential to become an express written agreement, the licensee shall give to a prospective buyer, seller, landlord, or tenant a list of the licensee's duties. Licensee shall perform all duties that are established by the commission. So that would have been a violation of broker duties. And then regarding disclosure, she was supposed to disclose, she or he, the material interest of a familial relationship, honesty and reasonable care in that disclosure, and then we go down to the qualifying broker supposed to supervise that activity. So we have to follow the rules. And then, what did the commission do? And much of the decisions, I'll tell you, have to do with the response. Did the respondent respect the process? Did they come back with a good file where they could defend themselves? Were they responsive to the investigators, or did they blow off the investigators? Did they try to provide as much information as possible to the investigators? And in this case, we felt like it was an innocent oversight on her part. She wasn't thinking it through, that she disclosed the relationship to her own sister rather than to the buyer. But when we're asked to look at something, and this is why I say this is a really, really hard thing to do, because it was an accident, but we're asked to determine, was there a violation? And so, yeah, there was a violation. Those people were not told. So what we do, though, how you kind of mete out the punishment has to do with the response, any type of feeling of regret or remorse about it, that it wasn't blatantly done on purpose. So in this case, they offered a pre-NCA settlement. And so we have the buyers and the sellers of the subject property were the sister and brother-in-law. You stated in your response to the complainant that you made such disclosure, but the disclosure was in the listing agreement, not in the purchase agreement. In the interest of avoiding time and expense involved in a formal disciplinary hearing, the commission has authorized me to offer you a letter of reprimand, a $500 fine, completion for no continuing education completion of no continuing education credit, a 4-hour course deemed appropriate by the commission. And so you have 30 days to accept this, and if you say, no, I'm not going to settle, I didn't do anything wrong, you have the right to go to a hearing. And I described that hearing process to you, where you can bring a defense attorney, defend yourself, and see what the commission rules on after that. Many times people accept the settlement agreement. We've made an improvement to our process, where previously you would receive this letter, but you would not receive a copy of that letter of reprimand. So who's going to say, okay, I'll agree to that, and then not know what the letter says? So it was brought to our attention, and I'm so glad that it was, and that process has been corrected. So now, with this letter, you would get a copy of that letter of reprimand, and you could determine whether you're willing to accept it or not. And so those are two cases that, yes?
They were found in violation of non-disclosure of relationship,
Right.
but there was no violation for the well situation?
No,
Interesting, okay.
no, we didn't see it that way. Yes, sir?
It just seems though that they're agreeing to doing something in their agreement that's illegal. So how can you agree to do something that I'm interpreting is illegal?
I don't understand your question.
So, in other words, you've got a well that's certified for one property. You have an agreement to share it. And it's my understanding from what you were saying that the state's engineering department said it was only good for one property. Yet they're agreeing to share it with two properties. So it seems that that's illegal, so how can you agree to do something that's illegal?
No.
I'm not saying it's a broker's fault, but
Right.
how can you agree to do
We
something?
looked at it like it was disclosed to the buyer that the well was on the adjacent property, and the broker's due diligence was to make that disclosure and let the buyer determine, am I interested in pursuing this or not? And if so, advise that person to get a proper well share agreement drafted. As to whether they were to determine whether it was a legal well or not, that would probably be a good practice, a better practice. But in that case, we felt like the buyer had the information and could have questioned more. One thing that I found interesting about this case is that when I've been involved with well share agreements, generally they're recorded and they go with the land. So I found it interesting that this one was specific just to, the two parties without just running with the land like an easement or an encroachment agreement would. Yes?
I will tell you, Kirsten, I have a subdivision with 32 wells. And it was one of the reasons a new developer decided, in spite of what we feel as realtors, it was one of his reasons for hiring a homeowners association separate from the owners so that the state of New Mexico absolutely knew who was managing the whole operation of all of the 32 wells.
Yeah. Generally, in my experience, I've had quite a few problems with well shares, so it's something that I'm always very concerned and cautious about. So, yeah. Okay, so I brought up the broker bees first because that's where we're applying the rules, and that's where the rules become so important. And that's why when we make changes to the rules, if there are trickling problems and things, we see those problems coming back around in complaints, and this is where we realize we've got to clean up the rule. So now we're going to look at the rules that we are looking at changing. And there were handouts, so you might have a paper version of this, but okay. So, and the way this works is we have a task force that is mainly comprised of commissioners this time around, but generally we will appoint a chair to a rules task force and then other members, and they'll consider how is the best way to make these changes, and they'll bring it forward to the commission. We'll look at them, we'll determine which ones we want to put forward to the licensees, and that always happens in a hearing. So you have the opportunity in a public hearing to come and comment on these changes, tell us if you think we should do it or not do it, tell us if you think we can improve the language or not. Rules hearings are grueling. It's not something we ever look forward to, but I invite you to participate because, as I said before, more minds are always better than one. So first thing we're looking at now is clarifying what has come to be known as the supervisory affidavit for qualifying brokers. It causes a lot of confusion when qualifying brokers are renewing their license. Basically, what we're doing is saying that in that affidavit, you're acknowledging that you have responsibilities to your associate brokers as a qualifying broker. So it's just that we want to kind of refine in the language what it is so people can understand it. They become confused by the title of the form. And then we're going to look at the rule language. What would it look like if the salesperson exam were substituted for the broker exam as the entry-level exam for associate brokers? So you may not know this now, but when a new person gets out of Kaplan and wants to go and take the test, they're actually taking the broker test, not the salesperson test. And that was an effort of some commission, not mine, or some group of other commissioners to kind of raise the bar and make the test a little bit harder, I think. And so that was actually put into the rules. And so the fail rate has been quite high for salespeople who are particularly young, because the difference between the broker exam and the salesperson exam is the broker exam has more kind of real life experience type of word questions where you have to kind of work your way through it without just memorizing what you were taught in Kaplan and then spewing it back on the test, A, B, or C. It takes reasoning. And if you're brand new to an industry, you may not have the ability to do that reasoning. And so the fail rate has been higher. So we looked at changing so that we would have two tests again. You'd have the salesperson test and then the QB test or a broker test when you want to go up to be a qualifying broker. But we can't just make that decision as a policy. We have to change the rule. So that's why that's up here now. And then we're looking at a rule change to amend Part 13 to expand from 10 hours to 12 hours for continuing education credit an approved instructor can earn. So you think about these guys, they spend all their time teaching these courses, but they don't get credit for the courses. And so at the meeting I argued, well, I think you can learn a lot by teaching, but teachers can also learn by watching a class or having to take a class. So we don't want to make it so that the teachers can get all of their hours by teaching and never having the opportunity to be taught. So we're going to be discussing this and debating this, but it was brought up that particularly core course instructors are affected by this. And I have a couple of comments. You first, and then you, Ian. Oh, did I?
Owner Resident Relations Act.
No,
Link, yeah,
oh, yeah.
right there in the.
Language that would be the third bullet.
Property
Oh.
managers.
Let's see, wait a second.
The third point.
Oh, thank you. Thank you. Appreciate that. Ian, did you have something on this? Okay. All right. Thank you. So language that would require property managers to take the Uniform Owner-Resident Relations Act only once upon the execution of a property management declaration instead of during every 3-year cycle. That has to do with the fact that that class really doesn't change, and making the property managers take it once every cycle is kind of like the torment of taking the mandatory course every cycle. So that's something that we would look at, or figure out if maybe there's a substitute course that would work. Then let's see, we got that one. Add language that would close a loophole in Part 13, which currently allows brokers to earn continuing education for attending their own disciplinary hearing. Yeah, that really happened. And well, this is one of those great examples of, you can't think of everything. And so it did come up, and so we're trying to kind of close that loophole in the rule. Very clever. Restore previously existing language to Part 19 that would require written disclosure to all brokers involved in a transaction where there's a limited service broker involved. That was erroneously removed from our disclosures. You may remember that it used to be in the broker duties to make that disclosure, which I think is only fair. If the buyer broker is going to have to deal directly with the seller, it should be disclosed to them up front. So that was a mistake, part of the trickle of rulemaking. So that we're going to work on. Then there was another error that was put into the rule. Remove the language from Part 19 that requires brokers to disclose all written agreements that a broker or brokerage has in a transaction. The intent of this was to disclose written agreements with transaction coordinators, and it was erroneously left in there. And the problem that it's causing is for companies who have referral agreements, they do not believe that the customers should have to see the referral agreements. And so that was a mistake, and we're going to be looking at that. Now, there's, the commissioners, we are subject to the Open Meetings Act, so we can't talk to each other between meetings. We can only talk to each other in a public setting. And I know in the last meeting, one of our commissioners really was not opposed to the idea, feeling that full disclosure and transparency is good. So I suspect that this will be debated. It was accidentally put in here, but there may be a commissioner who wants to leave it, and there may not. I don't know. We'll have to see how the conversation goes. So you look at next one, Part 24. Property managers and not all brokers. Property managers and not all brokers have the obligation to hire licensed, insured, or bonded vendors to conduct repairs and maintenance. Now, circling back to what I mentioned earlier, think about the case that Ashley was teaching us about with this idea of negligent referral. So if you refer someone who isn't licensed, are you going to be sued for $285,000 if a house burns down? This is something that we'll be discussing. This is it wasn't on our radar when we brought this up. When this was put into the rule book, there was no intent of having the sprinkler repairman have to be licensed, or the painter have to be licensed. Really, we were looking at people who are working on gas appliances or, electrical, things that would really, a roofer would require, for everybody's safety, a license. But this is going to be an interesting conversation. Yeah, I would encourage you to kind of attend the rule hearing or at least submit to us an email with your comments so that we can consider that as we decide. Yes. Oh, excuse me. Yes, Mark.
So is this in rule and reg now, or is this something that's being considered?
It's currently in the rule for property managers is the intent. It wasn't for all brokers, it was just for property managers. And the reason for that is because property managers often work as an agent of the seller. And so that is such a liability that they're obligating the seller to unlicensed people. And that's the reason that was put in there. Sure.
Anyway, about 15% of my business is property management, 85% is sales. So my understanding, I just went through the classes. My understanding is that this applies mostly to electrical systems, plumbing
Right.
systems.
Things that he's saying that his understanding is it would apply to electrical, plumbing, things like that that would require a license. That was the intent,
Right.
yes.
So let me ask you this. So we have a leaky faucet, and historically,
He's talking about a leaking faucet.
a leaking faucet, so historically, a licensed handyman is taking care of that work. Is it required now that a plumbing company is going to need to come in and repair a leaky faucet?
Yeah.
Because if that's the case, that's a nightmare.
Yeah.
Why would you impose that on property managers and homeowners, property owners who really are concerned about their bottom line? I mean, where's the health and safety concern with something like that?
Look at it in the context of lead-based paint, the same way. You've got to hire a person who's qualified to.
So we had a couple other people, though. We had Bev. We've got this gentleman over here.
So, Mark, there's actually a vendor, since I'm involved in form, there's actually a vendor certification form, and on the second page, it tells you what you don't need a license to do.
And, but interestingly enough, a licensed handyman can only make $7,200 a year, and that is in the construction industries. But a licensed handyman can't do plumbing. So you don't need a license to do painting, and you don't need a license to do yard work and cleanup. But one of the things that's real clear is that you can't tell the seller who they have to hire. So your seller wants to send their handyman over. You don't have any control over that. You're not being monitored on that, but it's who you physically hire as the property manager. And the other thing that Ashley pointed out was, I don't do property manager, but as a broker, I'm not typically hiring people to do the work. In other words, I'm not paying them. And she felt that if I give my client names of licensed people and they elect to go with somebody who's not licensed, that's not my fault and not my problem. But that I needed to be recommending licensed people. But this rule that went into effect is buried in property management. But since it doesn't specifically say property managers will, all of us have to, if we're hiring.
Yeah.
But you do hire people, I don't.
Yeah, as a property manager, you would. So I would say, come and speak to us about that, Mark. So we had Ian, and there's a gentleman here too.
So not long ago, is this on? I can't tell. Not long ago, I was going through the course on lead-based paint, and for property managers in particular, you do have to hire somebody that is certified, and because they're going to be disturbing, presumably in older properties, the paint surfaces. So where this seems to be heading is that property managers are going to become a specialty, in my opinion, in our industry. I don't think you can be a part-time property manager, and I have been one since I was 18 years old. So it's changing rapidly, and I think we're being put to a different standard, particularly in light of this negligent referral concept. If that gains traction, we're going to find that we probably don't want to recommend anybody about anything, because if your referral goes sideways, you might too.
Yeah. So, and this gentleman has been waiting, yes.
To address Bev, I believe in New Mexico, handymen do not have to be licensed, but they do have to have that limit as to what they can earn.
No, there's a handyman license issued by construction industry.
Okay, I'll talk about it. The other thing is a widely defined maintenance. What is maintenance? What if I have a guy come clean up leaves? Does he have to be licensed, bonded, and insured?
No, that wouldn't have been one of the things, or, you know, that type of thing, no.
I'm going to get my steps in today.
Okay, this is just a quick thought based on the recent Realtor ad on TV, or where we're seeing it on the web or whatever, about how we're the resource for referrals, I guess. I mean, I can't remember the ad enough to quote it. And so in light of this discussion, I'm afraid to give people names.
Yeah.
And yet, it looks like from that we are Realtor, you know, that it's almost like it's our responsibility, or it is what we do. We are Realtors. It is what we do. We refer people out.
Well,
Expect that from us.
yeah,
That's what I'm looking for.
One thing about that is,
Clarify it for me.
fortunately, Ashley is, you know, so sharp, and she has put into the purchase agreement the paragraph that's saying you can't be responsible for the people who you refer. And she's also adding that to the listing agreement. Oh, it's been in listing. They're adding to the purchase. So anyway, that's language that will help, and I agree with you. It's getting to the point where you can't recommend an inspector, you can't recommend a repairman, and then you start to think, well, what can we do? You know, can an app do our job if we can't actually do our job? So the way I look at that is try to ensure that the people you do recommend are licensed people if they need to be, and are good, responsible people. You know, be careful who you recommend. But I don't know that we can actually do our job and not recommend anybody ever. That's what they look to us for, you know. So, yes, and we're getting close. It's 10 o'clock. I have some more to do. So if you all can stay beyond the hour. It was just an hour, right, Ken?
Well, we're set to stay here till 10:30.
Oh, good. Okay, we're good. I can do that.
So you take all the time you want, and I'll take the balance on a legislative update that would take about 5 minutes. So.
Okay, great. Okay, yes, Kathy?
Just one other thing. You know, our affiliates do so much for realtors. And when you don't feel you can even refer an affiliate, that is really hard, because as a CRS, we have great people helping us with our events, with our education, with everything. And so I just feel that it's really almost disrespectful to our affiliates who work so hard with us to service the consumer and to service the public. It's just how I feel, really.
Thank you. Mark?
And on that note, real quick, Kirsten, the affiliates that have direct association with the transaction, the lenders, anybody that goes in the house, we actually vet them here at GAR. They vet themselves, actually. They hold themselves to a standard of code of ethics that they developed. They also provide us with, if they have access to the home, they provide us with a certificate of insurance for additional, naming GAR as additional insured. And so it's not something we take lightly around here. So when you look at that affiliate list on gar.com, you can rest assured that if they have that position in a transaction, that they've got some standing. They're not just, you know, a guy on a bicycle with a ladder, right? So.
I called on Mark. Kent, I called on Mark first, and then we'll get you next. Yeah, I had called on Mark.
Hold on, Mark.
How this whole issue around negligent referral relates to the hold harmless in the purchase agreement.
Right.
We have a whole paragraph that talks about, listen, you may ask me for referrals, and I may give you referrals, and the reason I refer people is because of X, Y, and Z, but I'm not obligated or warranting the work. How do those two issues interface with each other?
Well, I'm not a lawyer, so I have to say that. I would say it'd be good to have a lawyer draft your own kind of disclaimer, disclosure about if you hand people over to them, you're not responsible for those people's actions, you know. But think about any contract. It's just a promise between two people. It doesn't really have any teeth of its own. So if somebody's going to question any paragraph of that contract and sue you over it, you know, you can use that to defend yourself. This was disclosed, signed, initialed. I told them again. But if somebody's going to say, I didn't hear you, they're going to sue you, you know. And I'm so sorry, sir.
So, as Ken had mentioned, there's an affiliate listing on gar.com. Is it an issue if you just refer somebody to a list and not a specific person and let them choose their own? Does that remove you from that
Again,
responsibility?
I'm not an attorney, so I can't give advice on that, but I would say that would be a safe practice. You know, that would be a good practice, a better practice than just saying, here's a guy, you know.
That's what we do as lenders. There's lists of counselors and so forth that we give the borrower, and then they have the right to choose who they want, and it was their choice then.
Yeah.
So.
Okay, so yes.
This is just a recommendation. This is what I've done is when somebody buys a house and they call me and say, hey, do you know a good contractor? What I do is I recommend them to the Home Builders Association. Just like somebody recommending us as realtors, we have to be licensed. And I really think that the general contractors and plumbing and electrical, there's nothing wrong with working with licensed ones. They did their part to get their license, and they keep their license up because journeymen, they do. They have to do their part. I don't think it's a big deal to have to hire one that's licensed. It's part of CID, it's part of what we do, and that's just a recommendation. I would highly suggest people recommend the Home Builders Association. I don't recommend anybody in particular, so that's just what I do.
Sounds like a safe practice. Yes, sir.
What's discouraging about it is that we can go out of our way to direct them, the buyer, the seller, where to go. They ultimately make a decision, and it still comes back on us. And that's, you know, how do you go around that? You don't make any decisions. You don't make any recommendations. And it seems like there needs to be something on the real estate commission's part to, you know, to support the realtors who have proven that their buyers or their seller did something without our recommendation. And we get supported as opposed to going directly to a ruling and being specific about, for example, maybe not investigating enough if the buyer or the seller hired the wrong person. Is that our responsibility too?
That's for the courts to decide, right? You know, so, and the commission.
The commission makes a lot of decisions along those lines.
And you have to remember the charge of the commission is to protect the public, not the realtor. We have two charges: protect the public, educate the realtors. So it's a very interesting line to walk. And this is why I say, for anyone who's considering becoming a commissioner, it's very difficult because for my 32-year career, I was sitting in those seats. And I'm one of you. And when you come around to the podium and you're suddenly having to protect people from you, it really, you got to put a different hat on. And so many of the rules are not designed to hinder the practice of real estate, but to protect the public from a practice that would harm them. So it's a very big distinction. Okay, let's go on to, where were we? Okay, so add language to part 32 that would require a broker buying property for their own portfolio to disclose that they're brokers. No, we had this is funny, it fell into the advertising section that you had to disclose if you're selling property that you're a realtor. But nowhere did it disclose that if you're the buyer, nowhere did it require that if you're the buyer, you have to disclose you have a license. It was actually on the forms, but it wasn't in the rule. So we're trying to correct that and make it a rule that you got to disclose if you are licensed and you're a buyer, and if you're licensed and you're a seller. And then we have to add that to broker duties, take it out of advertising, which was kind of a weird place for it, particularly for the buyer part, and put it into broker duties. So that's the next one. Move seller and buyer broker disclosure language from the advertising place to brokerage relationships. Amend the definition of property manager to cover brokers managing homeowners associations. This is kind of an interesting one. This has come up time and time again in cases. This would involve considering removing the language property management, real estate services as specified by a management agreement, which include but are not limited to the marketing, showing, renting, and leasing of real property. HOAs don't usually get involved in that, but the collection and disbursement of funds on behalf of the owners, the supervision of employees and vendors, the coordination of maintenance and repairs, and the management of tenant relations, and the preparation of leases or rental agreements, and this is the big one, financial reports and other documents. So as part of our HOA disclosure, the HOAs are the ones providing financials to us, and so are they doing property management as our rule defines it? So we're going to open that up and look at it. And yes, ma'am.
I'm part of your problem because I have been banging on this cage, kind of getting it going again, why somebody shoot me. But I was approached by an HOA company. They have a qualifying broker in place. They are considering making a change. I said, well, I'm not familiar with qualifying brokers having to oversee HOA management companies. Let me unpack this. I call Ashley expecting a very succinct answer. No, she said the way the rule is written. In fact, HOA companies are required to have a QB in place. So we kind of walked through that piece of it. So then I dig farther. There are no HOA companies that I'm aware of, except for one in the commission's jurisdiction, who has a QB in place. We're just ignoring it. And when we approached the commission, we approached an investigator, they said may. And we approached somebody else, and he said, well, you tell me what they're doing that would require them to have a QB. So, you know, we're not enforcing it. You have one company who's doing it and no other companies are doing it. So when you bring this up, the HOA companies are going to come out like screaming. So I'm just curious about what you think. Are you going to just clarify if it's an HOA company? Because right now, even our Uniform Relations Act doesn't tell me if I'm going to be a QB for an HOA, what do I need to do for what they are doing? Because they are not doing traditional property management.
Right, and do you own broker duties? That's another question. So I do not have any answers on this. This is being opened up for conversation, and that's why it's in here, because we realize there's a problem. And again, its regulation does not often keep up with practice. So we're looking into this.
And roughly when?
No, the task force is going to meet on the 7th, this Friday. And so we're going to start kind of digging around in this. And the task force has been kind of a sub-task force has been created that I sit on. Debbie Harms is a member. Scott Flores from our Education Advisory Committee is a member. And it's being administered by Tom Baca at the Commission office. So I would be happy for you to come. It'll be 1 o'clock on the 7th at the Commission office. And again, this is going to be a place where we're hashing language out and discussing it. It's not going to be where the answers are determined. We're just trying to come up with language that would be presented to the members at a rule hearing, and then you'd have an opportunity to object or comment, help us improve, and then it would be voted on.
Anybody?
I think so. I have to ask Tom. I think so. Those are usually open. Yeah, get me in trouble. Yes.
It's interesting because I do homeowner association management. But if you look at the contract, management agreement, that management agreement is between a legal entity. Because almost all the HOAs are incorporated. And we are engaged to manage the business activities of that entity. It's not really property. We are managing business activities. So the fact that I've got a QB and I do regular property management, that's just ancillary to the function that we provide as an HOA management company.
So the question here is, how do we define property management? That's what we're opening up, because currently property management is defined as someone who has a property management agreement with an owner who is doing the following duties, which I just read through. So we're looking at the definition to begin with, and that would be something where perhaps there needs to be a definition for homeowners associations and people who work to manage homeowners associations. Right now, all of that is left silent in the rule book also. Right.
A separate definition
Right.
or requirements or set of rules and regulations for the management of HOAs.
Right, where we're at. Yes, Mark.
Yeah, it's interesting. I'm actually the president of an HOA representing the developer, and we're interviewing HOAs right now. We put out our management contracts for bid, and the management companies are managed by the HOA, the association. So you bring in a QB for supervisory and management functions over brokers, over property management company, but I think a case can be made that the HOA management companies are supervised and managed, responsible to the HOA. And so they kind of represent the role and function of a QB in terms of supervision and management. So anyway, it's an interesting discussion.
It is. Well, and you think about, too, this comes up quite often in our cases. At what point can you take off your QB hat and you say, okay, I'm a QB in all of these other scenarios, but when I'm working for you at this homeowners association, I'm taking that hat off and I'm not really a qualifying broker and I don't owe any duties and I don't have any responsibilities under our rule book to the HOA. So that is one thing we're considering, is at what point can you take off your hat and say, okay, I'm a realtor over here, not a realtor, excuse me, I'm a licensee over here, and I'm a qualifying broker, but over here I'm not. And when I'm over here and I'm not, I don't owe you anything. So that's part of the question. How do we define this? So you can see there's always there are always more questions than answers. I think. Yeah.
Be licensed to manage HOAs.
Good.
As long as you're only working within
So with my favorite topic of property management, there's another one. So at this time, we can examine the requirement to put all deposits into one brokerage trust account before the deposits can be dispersed into individual property trust accounts. Oh. Yeah, okay, okay. So the corrected copy. Sorry if I gave him a short copy. So that has been a particular problem in commercial property management where they have multiple accounts for multiple properties. So it creates a bookkeeping nightmare for them, not with no intention of doing so. Again, we're trying to figure out what our definitions are so we can figure out what's required in what situation. So we have to define the term residential in the context of property management. Another rule change, allowing brokers, this is a popular one, it's a happy one, carry over continuing education credit hours to a subsequent licensing cycle. Wouldn't that be great? So, but just as always, when you're working in government, we're limited by their process. So we have the idea we want to do this, but they may not have a way functionally within their system to effect this. But it doesn't mean we don't want to try to put it in there anyway. So that's that. This is another fun one, I think. I'm in favor of this one. Consider allowing associate brokers to earn continuing education credit for the qualifying broker refresher course. So for those of you who are not qualifying brokers, it's a fantastic course. But the qualifying brokers take it for no credit. This was a very sharp commissioner somewhere down the line, wasn't on my committee, but they realized that that exemption where you have 65 years of age or 20 years, I think, in the business, you no longer have to take continuing education classes. So they couldn't require education for people who were exempt, but they put it into a different section of the book, which wasn't under continuing education. It was under license renewal. And so qualifying brokers take this course. They have to for every renewal cycle, but they don't get any credit for it. So somebody brought up the idea of, wouldn't it be great if we could have associate brokers take it, learn from it, because it's a fantastic course, and get credit for it. I think there would be a mutiny among qualifying brokers who are sitting there not getting anything but the education. Why does that mean? You know, people, it's like if you don't have your Fitbit on, your steps don't count. You know, it's like if you take a class and you're not getting credit for it, does the education not count? You know, unfortunately, that's how people think of things. And they resent it, taking it without credit. But you learn a lot from it. So this is one I'm in favor of trying to expose associate brokers to. I think it's a great class. Yeah, that's the truth. We need to resolve ambiguities in the transaction coordinator rule. It's not defined very clearly, in our opinion, as, you know, you make a rule and then you kind of have to see how it plays out. So defining exactly what it means to be a transaction coordinator, what they can and can't do, what they're responsible for, and what they're required to deal with regard to broker duties. You know, and you think about it, this is another perfect example of the practice going on and doing something for years, and it's not really addressed in the rule. And with the practice of of transaction coordinators, when the market gets really busy and the brokers don't have time to do all the back office things, they say, great, I'm going to get an assistant to do this. And they're, in some cases, even preparing the contracts. But the customer, the buyer or the seller, was never informed that this person was going to be in their business. Doesn't know who they are until they get an email from them, doesn't know their name, doesn't know whether they're licensed, and yet they're in the heart of their transaction. So we decided, gosh, we really ought to disclose this to the parties, that there's another person who's going to be intimately involved in your transaction, perhaps even preparing your contracts for you. So that's the reason this kind of rolled into the book, is we're doing this, let's create a fair practice for the public. And so that's what we created the rule for, but it needs to be defined a little bit better. So we'll be working on that. And then the last one is a particularly big issue. And we want to review and revise the qualifying broker's supervisory requirements. And the current requirements say, supervise all real estate activities performed by all personnel licensed or unlicensed on behalf of others as follows. Review and maintain all records and documents required for real estate-related matters processed by all personnel supervised by the qualifying broker. Sorry, that's a typo, the 90. Provide or promote appropriate training of all brokers and staff affiliated with the qualifying broker for compliance with real estate law and commission rules. Supervise advertising of real estate or real estate services conducted on behalf of others by anyone affiliated with the qualifying broker, and execute and maintain current written employment agreements or independent contractor agreements with associate brokers. And the reason that this has come to our attention is, if you think about a transaction and all the moving parts of a transaction, if you have somebody just responsible for reviewing check boxes and initials on contracts, two initials, one signature, you know, all of these things, does that tell the qualifying broker the meat of the transaction? How can they supervise the meat of the transaction? And sometimes what we see, you saw today the complication of the broker bees. And every time we're listening to those and we're considering them, we're thinking, what could have been done to avoid it getting to this place? It wasn't necessarily a checkbox. Usually, the checkbox is what happens when somebody's really mad about what happened to them. And they go back and they look for a mistake in the contract. And that's what they bring forward as the big problem. When the big problem was really, could have been avoided long before and didn't have to do with the checkbox. It had to do with communication. And it had to do with reaction and response. and willingness to own a problem and willingness to try to resolve the problem without just saying, no, I didn't do it, it's not my fault, and closing your communication. It involves talking to your qualifying broker and saying, gosh, something's wrong here. This is not going well, and I need your advice, before just taking an action that puts you on a snowball rolling downhill. And so I'm trying to figure out, how can we define supervision of the meat of the transaction? And so I started looking into commissions all around the country. What do they require their associate or their qualifying brokers to do? And there's a push, it's very interesting, there's a push towards requiring that the brokerage develop a policy and procedures manual. And in that manual, it says, this is what you do in these scenarios. And one of the things that's itemized is you contact the qualifying broker immediately, and you tell them when you think something's going awry, and you seek their advice. And the other thing is a responsibility for the associate broker to have ownership in their own training and ownership in their own proficiency, and a duty to come to the qualifying broker and say, this is going bad and I need your help. And it also, they also require that the qualifying broker be responsive. You can't just call them back in a week. You have to call them back within 24 hours. You have to call them back within 2 days. These are things that are defined in other states. And one state is even promulgating a sample policy and procedures manual. And so this kind of takes the heat off the broker. If you can say, qualifying broker, if you can say, you've gone over this. We've gone over the steps that should happen within this brokerage, and you didn't follow them. How can that be the qualifying broker's fault? I personally feel like there's a lot of responsibility on qualifying brokers for things that they weren't made aware of and they didn't have an opportunity to try to correct. And I really believe that it wouldn't have anything to do with the checkbox. So I'm thinking, what if we said you got to develop a policy and procedures manual? You have to be available to communicate with your associate brokers. You have to provide education opportunities for your brokers, and that's already one of them. And then what if we said, we supervise the paperwork of people who have been in the business less than 2 years? I don't know that having qualifying brokers spend hours looking through forms, check boxes, going bleary-eyed, that doesn't really help solve the problems. And I'm trying to figure out a way to put that into our supervisory rules. So we've got a couple of comments here, and because we haven't heard from Mr. Gugino, I'll call on you, and then I'll call on you, Mr. Caird. Yes.
Large companies, and it is very difficult to supervise quantity. It is even the mature realtors make big mistakes that the young ones might do as well. And so I've kind of, and I don't know what can be done about it, and I don't know that I'm making any kind of suggestion to the commission, but I think there's got to be some kind of a guideline as to how many ABs a QB can supervise.
Some states are doing that. Yeah, some states are requiring that they can only supervise no more than 20, or they'll identify it in their rule. Yeah, thank you. Mr. Caird? Ian?
To say that I think it would be, it'd be very Okay. I would think it would be very appropriate for the commission to put together at least the outline and then let other companies add to that suits their own business practices within their company. None of us can live inside of another person's head.
No.
And it's usually only when it's gone sideways that you've got that moment of awareness that says, now we need to supervise, and it shows up in your broker Bs. That supervising broker becomes aware of the issue oftentimes once the complaint is already well down the road. Yep. And how many people should you be able to supervise? I think 20 is an interesting number. I think 1 is tough.
Is that one yourself?
Yeah, sometimes it is. So I would think that the outline really ought to come from the commission to start with. Then within large companies that have a different dynamic than small ones, you can modify it to suit your purposes. But having managed one of the more interesting agents in Albuquerque at one point in time, I can tell you that there are things that are just well beyond your ability to know what went on and why, and what could I have done differently. I asked that question of myself. And it does drive you to want to become a recovering qualifying broker.
Mm-hmm. Yeah, that's absolutely true. And yes, ma'am.
I have a question that goes back to the transaction coordinators and teams or whatever. Oftentimes, I might be in a contract and I'll get the notice that I must make sure that so-and-so, and there might even be 5 people in there, get these emails. Is it really my responsibility to keep track of their people that they have hired, and some of them have gotten mad or something, or their communication gets messed up because, oh golly gosh, I forgot to send whatever document or whatever communication to their assistant, or 3 assistants down, or whatever. This actually happens in title companies an awful lot. I might be dealing with a particular closer, and I do my best to try to make sure it gets to the right people, but it doesn't always. But isn't that the responsibility of the top person the listing broker or the buyer broker, whichever side I'm on, the opposite side, to, even though they've hired people, and I'll do my best to try, but do you see my point here?
Oh, I do, yeah.
Yeah.
Yeah,
It gets very hard to, oh my gosh, I'm supposed to send this to 5 people. I don't remember their emails, or whatever,
Yep, I do understand.
Is that being addressed in any way, shape, or form with rules, regs?
Well, one thing to consider too, with regard to the policy and procedure manual, we also have to be very careful about trying to dictate a practice. As you know, we can't be restraining trade in any way. So you have to give general guidelines for this is a good way to do it, but then each individual brokerage has to have their own refined policies. And if you're curious about that, you can look at the Arizona Real Estate Commission. They have a sample policy and procedures manual. It's very interesting that I've been studying. So that's one thing to consider. And no, we're not getting into the weeds of communicating. Transaction coordinators communicate, how you communicate with them and that type of thing. But I will say that it's being made clear that whoever the transaction coordinator works for is responsible for their actions. You can't. This has come up in cases where the contract has a huge mistake in it, and the associate broker says that was the transaction broker or transaction manager, and the transaction manager says he told me to do it. So it's like, who's responsible for this? So a lot of what we're trying to do is who's responsible. And there, ma'am, there was somebody right behind you, and then I'll come right back to you. Sir, did you have a comment?
The association had it 20 years ago, RAVAC. I'm from Pennsylvania Association. I was on the committee for that. We had people, we kept all of our inspectors at arm's length. We had a sheet that we gave out with everything on. What happens when the inspectors you don't have on that list decide that they want to take you to some kind of action because they're not on the approved list? Just the food for thought. It's interesting the way the circle goes.
More questions than answers. Yes, ma'am.
Going back to the transaction coordinator, I am one, and my agent on all of the papers introducing the transaction lists me there, and then she sends a letter when she introduces to the different groups that please CC all correspondence to my transaction coordinator. The problem here is I also introduce myself immediately, who I am, please CC all correspondence. So many title companies, lenders, don't even say, hi Brenda. They don't bother. Your problem is not who do you go to or whatever. Sandra's very, very good about that. She asked them to do it. I introduce myself. Oh, who? And that's our problem because we're not yet really officially recognized. It's coming.
Yeah, it's coming. So we're out of time. Ken has something else to say too about legislative initiatives. Quickly, if you look up last year in 2018, we had 133 cases. Of those, 70 or 53% were closed or dismissed. 34 or 25%, we offered a pre-NCA offer, which is the settlement that I shared with you earlier. And 29 or 22% actually went forward to a hearing. So it gives you an idea of how it breaks down. But 50% of the cases are oftentimes something we don't cover. They're frivolous, they're trying to be spiteful, sometimes they're romantic problems and all kinds of things that don't have to do with what the commission deals with. We do have some upcoming hearings. These are very interesting and very informative. They're all here at GAR. Thank you again, Kent, for sharing the facility with us. So we have February 13th, 9 a.m., February 25th, 9 a.m., 27th, 9 a.m., and 28th. You get credit for attending these, and you also get a lot of good information in the process. And
We'll post all those on gar.com.
Great. Thank you for taking the time to listen to me. Thank you.
So, Kirsten, thank you so much, Commissioner. We really appreciate you being here and your help. She does this as a volunteer. It's absolutely amazing what she throws herself into, and all 5 of them have thrown themselves into this world and to take all these bullets constantly and really for the love of the industry and for you all. So give her another round of applause. Thank you so much. So you are free to go if you like. And then I have a question for the rest of you. It is 10:38. We were scheduled to be out of here at 10:30. I am happy to stay and do a 5 or 10 minute update on the legislative activities in Santa Fe. If you would like to stay, you're more than welcome. If you need to leave, I will not get my feelings hurt. So, and did you find those cases interesting? The first one I think we should call the Caddyshack case, right? That was it would be a lot of fun, but. So if you need to leave, that's fine. Also, we're really lucky to have in the audience today a former state senator, Mark Boitano. Mark, you want to just wave real quick? Everybody knows Mark. Thanks for being here, Mark. Again, another highly paid position in state government. If you keep adding up all the zeros, it's still the same. Anyway, I got to be very good friends with Mark because we sat very close together on the Senate floor. For about 12 years. He was up there, I think a little longer, 16 or 20 years that he was there. So a couple of things that are going on up in Santa Fe. This is a budget session. Every other year it's a 30-day budget session. And the discussion is limited to those items that have something to do with the budget. And so what legislators used to do is just throw an appropriation on some bill just so they could discuss it. Well, that's pretty much not allowed anymore. They don't let them do that. They put some committees in the way of that. So all these bills that people want to hear have to go through the committee first to be ruled germane to the session. There's 2 things that make them germane to the session. Number 1, they actually have something to do with the budget. Number 2, the governor has authorized by a message to the legislature that she's willing to have that discussed. And so they go through their respective House or Senate committees to be ruled germane. Once they're germane to the session, we start tracking them. And there's probably a list of about 50 bills that are being tracked that have something, or maybe more at this point, something to do with our industry. Whether it's the cannabis bill, which oddly has a lot to do with our industry. And Colorado has taught us a lot of lessons about that. We're pretty close to some folks in Colorado that are helping us to sift through the good parts and the bad parts about these cannabis bills that are going through. My take on the cannabis bill is that the governor sort of stretched out a little too far in some of the things that are being asked for, and that she won't get a bill this year. It probably won't make it through Senate Finance, if it even gets that far. So it's probably not something that's going to happen in this 30-day session. I think the wiser heads will prevail and say, let's talk about this for another year and save this for a 60-day session, which is the general session next year about this same time. And so that kind of takes care of that whole cannabis discussion. It will be deferred until the interim and probably taken up then. They could surprise us too and collect enough votes to get that done. But at this point, I think it's just there's too many extraneous elements in that bill that make it very complicated. As if it's not complicated enough already, they've kind of loaded it up with other things. So that's one thing. So how we handle deciding our legislative priorities, it starts earlier in the year, probably in the summer. We have a legislative committee meeting in Santa Fe with NMAR, the New Mexico Association of Realtors, and the legislative committee is made up of people from all over the state. So we get a really good representation of what people are looking at, what people are thinking from all over the state, which is a great perspective, especially when you're from Albuquerque. You got to look at most everything, but then you're looking at an urban sort of perspective, and it's a rural state. And so we have to make sure and be balanced on that. But we get together and we talk about what we would like to see. And so I'll just read this real quick, and we'll post this on gar.com. I think it may be up there already, but if not, it's going to be along with the rest of Kirsten's information. Number one priority was support favorable tax policies. We're going to oppose any transfer tax, any effort to put a transfer tax. There was even an effort a few years ago to constitutionally ban a transfer tax. Of course, we didn't get that done, but that's how much we hate transfer taxes. And we're just not going to stand by and let that happen. We want to support equitable property tax assessments, which means Steve McQueen's bill, House Bill 91, that came up as a fix to the tax lightning, which Mark is very familiar with, was, again, loaded with other things. And in one way, it fixed the tax lightning, but in another way, if you have a second home, you're going to be subject to a 10% per year increase in taxes. I don't know if there was a cap on that or a time limit or how they set that up, really. But, and he was really upset with us for opposing that. I said, Senator, don't run dumb bills, we won't oppose them. I didn't say that to him. And he's a representative, not a senator. I apologize. Support efficient regulatory environment. Support an efficient regulatory environment. What have we been talking about all morning? Just that, the New Mexico Real Estate Commission. We've forged a very good relationship with not only Wayne Sitio, but the commission in general and the commissioners. The staff is starting to come around to the idea that it's not us versus them, that we need to work together on a lot of things. So much so that we were able to work through some transfer issues, license transfer issues that came up. I think, the Realty One folks that are here, Gene, I mean, we certainly had some issues with transfers. Transfers were sitting on somebody's desk for sometimes 3 or 4 weeks, which makes a realtor subject to practicing without a license. Untenable. We could not live that way. So we worked out a deal. They brought their entire staff over, and we sat with them, with our leadership and myself, and talked through, and some of our staff members. Emmy Saavedra, she changed her name because she got married. Did you know that? Tell her congrats. Edwin's a great guy. But we sat across the table and said, well, how do you guys do this? Okay, well, how do you guys do this? And, to my knowledge, that's never been done before with the Real Estate Commission. And so we were able to work out a deal where, okay, you get all the paperwork together on the transfer, have the agent bring it down, we'll stamp it, we'll initial it, and there's a list of qualified initials that will be accepted. Take a picture of it, take it to GAR, and you're good to go, right? We fixed it because we talked to them. I mean, it was that simple, and they were happy to do it. And so, that's that kind of collaboration that we're starting to get better at, I think. Support increased efficiency and effectiveness of the New Mexico Real Estate Commission operation. I'm glad it didn't come up today. We all know that Wayne Sitio is on administrative leave. That's all we know. And we're not prepared to offer any more comments on that. And I'm glad it didn't come up earlier with Kirsten. So that's where we're at on that. Ian, the only thing we know is that he's on administrative leave. It's a personnel issue with the state. So we don't know reasons, we don't know why, who, what, when, where. It doesn't really matter. We're just not in a position to comment on behalf of our membership on that. Educate regulatory agencies on real estate issues. We've been working towards that as well. We're trying to make them aware of how we do business and what we need. The changes in the teams. You know, the team structure presents new things. We're going to require some new things and new thoughts to come around on this, to make sure that, because we all want the same thing. We want our clients protected. Well, who are our clients? The public. And so our missions are the same. It really doesn't have to be an us versus them deal, but there are a number of bad apples in a lot of baskets, unfortunately, at times. So we have to be sensitive to that as well. Support property management professionalism. I think Kirsten talked a lot about that today. We won't beat that dead horse. Deter copper theft, which is a really big thing with commercial brokers. Not so much with residential, but we do have a lot of problems. And in fact, it was in the newspaper yesterday, I think, a big article about people breaking into vacant homes and stealing appliances and things like that. Those are big problems, and we need to figure out how we can do something on our end to address and help with those things. Law enforcement is stretched to the gills, and it's really hard for them to be everywhere at once. So we really do have to come up with some ways. They're popping lock boxes, getting keys, helping themselves, and without any repercussions, really, because it's difficult to find them once they're gone. Cameras, surveillance, security. I don't know. There's just a lot of things that realtors could engage in with sellers to make it safer and better. We just have to kind of figure out what that's going to be. So another one was review and update the New Mexico Condominium Act. We've done a lot with the HOA Act, and the other part of that is the Condominium Act. And so there's language that's sort of conflicting between the two now that probably ought to come into line with each other. And so that is one of the requests from the NMAR Legislative Committee, is that we review and update the New Mexico Condominium Act. And lastly, support increased housing availability. And the point is that NMAR favors the creation of affordable workforce and senior housing to meet community demands. And so where are we at on inventory these days? It's pretty light. And so, as inventory shrinks and prices start going up, then you start approaching the point where, new homes are being built about that level. We're probably $80,000 to $100,000 difference right now between a new home construction and existing average price sell. And as those numbers get closer and closer together, builders are finding ways to pull the trigger on their projects. I talked to Pulte, I talked to Abrazo, some of these local builders as well. What we're missing in this market is the individual contractors that would build 1, 2, 3, 5 homes a year. And they wouldn't be the 250 or 260, they would be 300 to 600 in that range. Those guys aren't building those homes right now. Why? Well, it's 4 L's that Lawrence Yun talks about. Incidentally, Lawrence Yun is going to be a speaker for us at our annual meeting in December. So you want to make that meeting. But it's the 4 L's. It's labor. There's a labor shortage. They're all shipping down to Facebook, Mesa del Sol, all these other projects. And the oil patch is drawing a lot of people out of our labor pool because there's good money to be made in the oil patch right now. So labor, lots, we're Albuquerque. We've got mountains on one side, reservations on the other 3, so it's kind of tough, So our growth potential is Valencia and Sandoval, infill projects, combining lots, there's strategies to deal with it, but they're getting to be fewer and fewer. So labor, lots, loans, always an issue. You know, rates are great right now, but you got to qualify, and the house got to be in the right price range, or you're not going to be able to be a first-time home buyer, and you all know that. Labor, lots, lumber, lumber, loans, right? Yeah, materials are expensive. So lumber's come down a bit, and steel's come down a bit because the tariffs are, you know, we worked some deals out with China, I guess, or whatever. But, you know, and those things change overnight. This coronavirus could change a lot of things overnight for our economy overall. Kind of scary. Mark, do you want to add anything to that? Kathy, I was going to introduce you before we break up. Kathy Olson, you all know, has been a federal political coordinator for 10 years, 5 years. So, right, and her job was to keep track of, well, first Heather Wilson, right? You worked with Heather for years? Oh, Carol worked with Heather. So she worked with Michelle Lujan Grisham as a congressman, woman, for the 5 years, and they love each other. They have a great relationship, not just business and professional, but personally they have a very good relationship. And that's important for us because she cracks that door open. And we've got that line of communication because now she's the state political coordinator with the governor as her policy maker that we need to be in contact with. And our goal was, well, this is NMAR's goal, but we're participating, is to have a state political coordinator in every legislative seat. And we've got over half of them filled at this point. Steve, Anaya, David Oakley, and myself do the best we can to fill those gaps with our relationships in Santa Fe with the rest of them. In fact, I printed off 50 or 60 RPR reports, the Realtor Property Resources, a part of Flex. There's an economic data report that they just love because you can print this economic data report and it's information that's specific to their district. And we give that to them. It's charts, it's graphs, it's tells them who lives there, who's coming, who's going, the average income, what they spend their money on, what religions they are. I mean, there's a whole bunch of information in that economic data report that they find very interesting, especially in an election year, because they want to know who their voters are. And so it's important, and they love when we show up with that report, and it's kind of fun. The governor got one for the entire state, plus I think we isolated Albuquerque, Las Cruces, Santa Fe, the urban areas, so-called, well, urban New Mexico style, right? We're still rural, but
I wanted you to
yeah.
talk a little bit more about our discussion with Chief of Staff regarding non-taxing Social Security and veterans retirements.
Well, my next thing was to introduce you as that, and you're gonna talk about that. Are you okay with that? Oh, all right. So, Kathy cracked the door open for a meeting with the governor's office. The governor couldn't be there, but she did send John Bingaman, Jeff Bingaman's son, is her chief of staff. He showed up and gave us about an hour and 30 minutes. We stayed there for a long time, and he listened to us. And one of our really only big ask was that the governor communicate to the Real Estate Commission that we stand ready to work with the commission through this tumultuous time. And that we've been helping, we want to continue to be helpful. And so he agreed to that. We really don't have any other things we're asking for other than, paying attention to what's on this priority list, which we really didn't have a specific set of bills or initiatives that we were pushing. And I think he appreciated that. We don't want capital outlay, and there's a bunch of it this year. We didn't go up there with our hand out. We went up really just to be helpful. But there are some things that we identified for him that would be helpful, and that is attracting retirees and veterans to New Mexico by not taxing, like most states don't tax, Social Security benefits. And we've paid in after-tax money all these years, and then we get the benefit, and it's taxed again. And so it's not fair. That's one of the things, and he seemed to have heard that, not just from us, but I think Senator Jim White is running a bill that will do that. And there may be a cap of $25,000 or $30,000 on that, but that covers most everybody that's getting Social Security benefits anyway. So those things are sort of in the works. We'll find out how that goes. It's germane to a budget session. They're talking about it. It'll go through all the committees, and I think deadline to introduce legislation is closer. It's already passed. But once that's done, then the final 2 weeks of a 30-day session moves pretty darn quick, identifying bills that are germane to the session, that deserve attention. And some of them will just die and never be heard. And that's okay too. We don't need more laws, right? So any questions about the process and how we do this on your behalf, Jack?
Not really the process, but Kathy mentioned relief for income tax on veteran retirement funds as well. It's the first time I heard that. I knew about Social Security, but you didn't mention veterans. Is that actually a part of what's being discussed?
Yes.
That's been on the table for a long time. I mean, Mark and I saw that idea floated around there.
It's just gotten stuck.
I don't do a lot of business with out-of-state buyers, but in 16 years in the business, I probably had close to a half a dozen veterans who I worked with who decided not to move to New Mexico because of it.
Right. And with oil and gas being what it is at the current time, I can tell you that changes some things. I mean, we've been there in years where there wasn't money. Wasn't new money, and we were in the hole, and all of these boards and commissions lost their savings accounts essentially to the black hole of the general fund. And Mark can tell you there wasn't a lot of capital outlay to distribute around the state. Capital projects were suffering. That's why our infrastructure is suffering and needs help. So all those things are considered, but it's considered on a year-to-year basis. And the dynamic scoring of the budget doesn't exist really much. They don't give credence to the fact that if we do this, we're going to draw, another 50,000 people to New Mexico that have big bank accounts and they spend money. They're called retirees, and they're pretty easy keepers because they don't use schools. They go to church and home and shopping and whatever. They're just easy keepers, and we should be paying attention to some of those folks. Linda?
I went to the legislative breakfast. You were there. And what I thought was amazing, and I've told a couple people, that Ms. Bernstein got up and asked the panel of legislators, what kind of budget do you have for the New Mexico Real Estate Commission? Only one of the legislators knew what the Real Estate Commission was. And it's only because she just got her license, and the rest of them had this blank stare, and one of them went into a long litany about, well, you'd have to show me what they do, and I'd prove that they need the money. And do you think that's going to get any better? It was kind of frightening.
Well, I can assure you that the members of the House Appropriations Committee and the members of the Finance Committee are intimately familiar with what the Real Estate Commission does. So it depends on who you're talking to. Some of those folks, Kelly Fajardo is who you're referring to, that is recently licensed. She's a member of GAR. She's a state representative. She's from Los Lunas area. And so, good gal. She's always in our corner. She's a champion for real estate issues. And most of them are. To be honest with you, Democrat, Republican, doesn't matter. They own homes of their own, and they understand a lot of our issues. When it came to the commission itself, that is a line item within the Regulation and Licensing Division budget. And the Regulation and Licensing Division encompasses all boards and commissions, and there's, 50, 60 of them. Probably 12 or 15, but I mean everybody that's in their budget. There's just a bunch of different line items in there. So we looked it up. I think it's Isaac Romero is on our legislative committee. He's a commercial broker here in town. He used to work at the Legislative Finance Committee. They draw the budgets up for the legislature. So in the LFC version of the budget is $1.8 million for the Real Estate Commission, which is an 18% increase over last year. Part of that money is going to be gobbled up by home inspector licensing. So I don't know how much really new money they got out of this budget session. We asked them for more. We said, you need to do better. And so where that goes, I don't know. We'll lobby the Senate Finance Committee and see if we can get an adjustment closer to the end of the session, is all I can say. And that's if Steve, I don't operate up there autonomously. There's no way I could. Steve is organizing, Steve and David are in charge of organizing our lobbying efforts. So we try to work in collaboration on everything we can agree on. So, other questions? Mark?
Yeah, I have a question between Laura and the commission. So on some of the things that came up today with Kirsten, like negligent referrals, some of the property management issues, contractors, would it be best for those that are concerned about that and would like to give input to the commission to go directly to the commission, or for us to create maybe a task force here of licensees that could come up with some recommendations and then go to the commission?
Good point. That would be something that would be probably great to bring up to the executive committee and see if they would want to forward that to the board for either an ad hoc or special committee, if there are truly things that we need to get done. And I would tell you that the commissioners are all incredibly open to those conversations, and I don't think any one of them is going to not answer your call if you have questions, concerns, ideas to share. They've been very open to a fault. They've been very open with us. They come here and have their meetings. We stream them around the state so that people in Hobbs can get credit for coming to a meeting, but they only have to go to Roswell and not Albuquerque. That's a haul to come up 5 hours, usually spend the night and 5 hours back for a 1 hour commission meeting. QBs are required to do it. And so, you know, that's the kind of things we're doing to collaborate with the commission these days. I feel pretty good about that. But not a bad idea. We do have a staff member here, Claire Conrad, spent several years as an employee at the commission. So she's intimately familiar with their operations and provides a lot of input for us on a regular basis. So they liked her. They're really mad at us still for taking her away. But we have benefits. Well, she had benefits there too. We love Claire. She's doing a great job for us. All righty. I think we can call it, and thank you guys very much for being here today. We really appreciate it.